welcome to the Diamond Room. You're about to hear from Lynn, talking all about estate planning. So enjoy, and I'm sure she's gonna answer all of your questions, and we should probably stand here and listen as well. So again, thank you guys so much for being here. Lynn?
Thank you. Thank you, Leslie. So appreciate that welcome. Leslie asked if I wanted to be introduced by her. I said, absolutely. I want star power in the room. She's so gorgeous. I think we all know Leslie Lowe. Leslie, thank you so much. Appreciate it. All right. My name is Lynn St. Louis. I'm an estate planning and elder law attorney. I started this journey back in the early 2000s when my parents started needing help. And so sometimes the reason we do what we do is because life just guides us that way. And prior to that, I had been a litigator, which was a lot of fun when I was young, but not so fun as you get older. So in 2006 is when I started Elder Law Group. We call it ELG Estate Planning for the most part now. Anybody know why we don't call it Elder Law anymore? Not a single person in this room would consider themselves old enough for elder law. Fair enough? So ELG estate planning is clearly identifies we do estate planning. We do have a specialty in elder law. When we talk about estate planning today, you're going to see a little bit of what it means to be an elder law specialist, because the estate planning that we do incorporates what will happen if somebody becomes disabled or needs long-term care, or how to protect assets, especially for long-term care costs for your spouse. So we're going to get through all of that. But I know that estate planning and even meeting with an attorney can seem intimidating, and my goal is to make it not intimidating. I think what's really important to me is that people understand their plan and that they know their attorney cares about them, deals with them with compassion and respect, because it's important. It's important to you, your estate plan. More than anybody else, it's important to you. So that's what my goal is today. We are going to be, we have a lot of resources available. If anybody go to YouTube, my husband lives there. But he's mechanical. It tells him how to do everything. But we also have a YouTube channel that has a lot of resources and guidance and information for you. So you all should have a one-page flyer, yeah? So this is what is going to guide us during our discussion today. I prefer not to use a PowerPoint. Because I want all your attention on me. When I use a PowerPoint, all your attention is on the PowerPoint. I learned that from Jim Collins when I went to a recent event that he put on. As you know, this is just to provide education. I am not giving anybody here legal advice as to your particular situation, because we don't have an attorney-client privilege. So I'm just saying that because I don't want you walking away saying, my lawyer told me this. We'd love to be your lawyer, but we would need to establish a relationship beyond the room here. All right. So just a little bit more as we're getting things handed out. ELG Estate Planning, there's it's a firm now that started with me in 2006, and now there's about 20 of us. We have an office in Spokane, which is right by North Central. We have an office in Kennewick, in the Tri-Cities, and we have opened an office in the Seattle area, in the Northgate area. We really are very passionate about what we do, helping people understand estate planning, making sure that their estate plan is the right one for them, and being there for our clients as life goes on. Because if you've done estate planning, you probably know one is not done. You get it done, and then life goes on. And then what has happened next? It's always a good idea to be able to know with confidence that you can go to somebody who can help you, that will be there for you. The reason that we've expanded from just Lynn to a big team is, I get it, I'm mortal too. So we need everybody, we need to have what we call a legacy law firm to be there for our clients always. All right, we're gonna go ahead and get started. On the first page of your flyout is flyer. Where did that flyout come from? I'm not sure. So on the first page is, on the left-hand column, you'll see durable powers of attorney and then healthcare directive on the bottom. And on the right-hand side, you'll see revocable living trust, will, and non-probate assets. We're going to talk about all of those things. Let's start with not a will and not a trust, even though I'm sure all of you are familiar with that term, but with durable powers of attorney. Because you might think that your will is the most important thing you can have. I would disagree with you. Your durable power of attorney is the most important legal document you can have. Why is that? The will takes effect when you die. Who has to deal with your estate? Not you. The durable power of attorney, if needed, takes effect while you're alive, but you become disabled. And if you become disabled, somebody else needs to be in charge of your financial affairs, your personal affairs. So we're going to talk about the consequences of not having a good durable power of attorney. So by a show of hands, who has an estate plan in this room? Next show of hands. Who has an estate plan that was prepared either by an attorney or off of the internet? I don't care. Just who has an estate plan that was one that you thought about? And for the rest of you, and actually congratulations, I mean, you are a smart room. You have estate planning, the majority of you, and you're here to listen. A lot of people don't want to talk about this because who wants to talk about disability and death? I personally would rather talk about going on a trip somewhere where it's beautiful. So I really want to say congratulations, for being here, because it's not the sexiest subject by any means. So in any event, so if you don't have an estate plan, surprise, you do have an estate plan. It's just not one you've prepared, because the state has a default estate plan for you. The default estate plan is the state has to do something. I mean, they have to, if you were to lose capacity such that you can't make your own decisions and you don't have a durable power of attorney, has anybody heard of a guardianship? That's the state's estate plan for you, is a guardianship. A guardianship is a court-ordered proceeding where all of your information is filed in the superior court of the county where you reside. And maybe they'll appoint your spouse as your guardian. Maybe they'll appoint somebody who you've never met before who's called a professional certified guardian, who are wonderful people, but you've never met them, and why the heck would you want them in charge of your affairs? Well, if you haven't proactively taken action for a durable power of attorney, and believe me, I'll get into what it is, etc., the state has a plan for you, and that's not the plan that you want by any means. And just to let you know, if you don't have a will or a trust or some other way to dispose of your assets, your estate when you're gone, when you passed away, the state has a plan for that too. It might not be the plan that you would want. So not doing your own estate plan means that you are going with what the state's estate plan is. And we don't recommend that because that typically isn't the ideal plan for anybody. Fair enough? Did anybody learn anything there? Did you know that the state has an estate plan for you?
No.
They do. All right. So we're going to talk about the most important documents, your durable powers of attorney. These are what I call your living documents. Why? They're in effect while you're alive. A durable power of attorney simply is a document that you sign where you appoint somebody, hopefully somebody you trust and somebody who is capable of managing your financial affairs and also managing your personal affairs. I broke them out separately here, financial and healthcare, because we believe that they work best when they are two separate documents, but they don't have to be. They can be a combined document. It's just that sometimes somebody says, well, I want my daughter to be in charge of my health care, but I want my son to be in charge of my finances. And so it makes sense to break it out separately. Also, when we do durable powers of attorney, ours are very comprehensive. The importance of it is that you want it to be accepted by whomever the person is handing it to. So if it's at a bank, we want the bank to say, oh, this looks right. So that if you need somebody to act on your behalf, that person you've appointed, they're called your agent, your POA, your attorney in fact. It all means the same thing. Who did you appoint? And if you can't make your own decisions, they have to. And if they have to, we want the bank to accept the document as valid and not give them a hard time. Because that's what's really important about the powers of attorney, is that the document is accepted and works for you. So the financial, what's really important about your durable powers of attorney. And by the way, if you have questions during this phase, just raise your hands, because your questions are actually going to be really smart, and I'm going to make me look smarter as I answer them. So your powers of attorney must be durable. They must say that. Why? If they don't say that and you lose capacity, the document's ineffective. Like, why would you ever have a power of attorney that loses its authority when you can't do anything about it? So make sure your power of attorney is a durable one. It will say durable on it. Make sure, I'm going to go in order here. Effective immediately or upon incapacity. We work a lot with retirees. We work a lot with people who are aging. We work a lot with people who are concerned that they might lose capacity. So we work with a lot of smart people is what I'm telling you, because these folks know that this is potentially planning is what you need to do. So we often have clients who might be facing some sort of cognitive decline. Maybe they even have an Alzheimer's diagnosis and they come to see us. They, as long as they can still understand what I'm saying, what one of my attorneys is saying, they don't have to understand every single detail, but do you know, have you ever communicated with somebody who has dementia and you know they're following you, you know that they're okay? They might have Alzheimer's, but they're tracking. And then maybe sometimes they aren't, and you know that as well. But when somebody, even if they have a diagnosis of some sort of cognitive decline, it is not too late. We know when it's too late, because then they're just not tracking at all. And then that's unfortunate, because when somebody doesn't have a durable power of attorney, they are going to need a court-ordered guardianship. As elder law attorneys, we do everything to strive to make sure that we can get them to sign a document when it's kind of questionable. I have literally gone to somebody's house 4 times before I saw she had a good enough day to sign that document. Other attorneys don't do that because they're concerned. It's like, you see incapacity once, that means always incapacity? No. If you've dealt with anybody with cognitive decline, you know it waxes and wanes. So it's just when they're signing the document, they need to understand it. And I'm spending a lot of time on that. My actual advice to you is don't wait until it's too late. I'm just sharing this because we work with a lot of people who have waited a long time, and we strive to help them, and sometimes we can't, and when we can't, they'll be under a court-ordered guardianship. So why am I talking about that when I'm saying effective immediately or on incapacity? Cognition waxes and wanes. If you put in incapacity, and maybe you've appointed your daughter as your attorney in fact, and she knows that you're struggling, and she knows you need help, and sometimes you know it, sometimes you don't know it, and then you go to the doctor, and the doctor or 2 are supposed to say you have incapacity. The doctor sees you on a good day, you look great. No, you're not going to get the durable power of attorney effectuated by a statement by the doctor that you're incapacitated. That's problematic. So there's this gray period that your daughter can't act for you at all, and what's going to happen during that time? Not good things. Sometimes people say, well, I don't want to make my power of attorney effective immediately, which is what we recommend, because I don't want them to take action for me. Say, I don't either. I mean, I have an effective, immediately durable power of attorney that names my husband, and you know he's not gonna act for me on decisions that I can make, because the person you appoint they're called a fiduciary. They must act in your best interest and must do what you want, and they can't take over your life. You have to trust them, they have to be reasonable, and they don't take action until action is needed. So if you're worried you've appointed somebody who's gonna step in and take action and throw you in the nursing home, wrong person. Don't name them, name somebody else. Effective immediately means that when they need to act, they can act, and they don't have to fight the medical system to get the authority to get the power of attorney accepted. Remember, it all comes back to, for a power of attorney to be good, it has to be durable, and it has to be accepted by whomever it's presented to. More of a concern with financial than with personal, because the doctors don't have the same issues that the bank or the investment company has. So does all of that make sense? Okay. Also, make sure, in addition to naming a trusted person, name successors. Don't name joint people. Don't say, oh, I got 3 kids and they're all great. They're all gonna be my powers of attorney. Bad idea. You do not want a committee. You want somebody, the most capable person, the person that you really have the most confidence in, to be named first, and then you name the second child, whomever. It doesn't have to be in age order. We know all of our kids are so different. I mean, I wouldn't put, never mind, this is being filmed. So name successors, because you want, estate planning is all about the what ifs. What if you and your trusted individual you've named are in that car accident together? Name another person, then name a third person if you can. These are the fundamentals of powers of attorney. They avoid a guardianship. Remember what I said about a guardianship? That's a estate plan for you if you don't have a power of attorney, a durable power of attorney in place. You do not want that. One of the things I think is important for people who are married, any married people in here, to know is that just because you're married, you don't have any legal authority to act on behalf of your spouse when it comes to finances. I mean, have you ever called on your spouse's credit card? Please put your spouse on the phone. But more seriously, maybe both of your names are on the title to your home. If your spouse loses capacity and you need to sell the home, or you want to sell the home, you cannot, because your spouse has lost capacity. And if your spouse doesn't have a durable power of attorney so that somebody can sign on the behalf of the incapacitated spouse, they're going to be subject to a court-ordered guardianship. So that means not only their finances, but your finances are going to be in front of the court, and the court is going to have to grant you authority to sell your own house. It comes as a really unpleasant surprise to couples that they can't take care of things. We're community property state in Washington. You think we could? No, you can't. So just because you're married doesn't mean you don't need a durable power of attorney. I'd say more so, because the spouse who's not incapacitated having to deal with this problem, talk about frustrating. So under the powers of attorney, financial and healthcare. Healthcare obviously deals with who's going to talk to the doctor for you. You're incapacitated, you're in surgery. You need a healthcare agent. They need to speak your wishes, to tell the doctor what you would do. Same thing, name successors. Because if you and your power of attorney are in that accident together, we need somebody else to speak for you. When it comes to financial, what I broke out here that I think is really important, because I'm an elder law attorney and we help people protect assets, especially against long-term care expenses, is that there needs to be certain authority in your durable power of attorney, so that if in the future you or your spouse needs long-term care, we can help you get state benefits without having to spend down all of your money. So what that means is, as an elder law attorney, when I see a durable power of attorney, I need to see authority to change a community property agreement, revoke it, to enter into a separate property agreement. And you might say, well, why is that? We'll talk about that in just a moment. If I'm hoping that we have time to cover that. It's for the reason of being able to protect those assets. Yes?
Sorry, could you repeat that again, please? What
Yeah.
you were saying?
So your durable power of attorney for finances, we really wanted to have, Washington State has all of these rules about what it's supposed to be specifically in your power of attorney. One of the rules is it has to specifically say that you can revoke a community property agreement or enter into a separate property agreement. It's called a property status agreement. Your durable power of attorney needs to have that authority so that an elder law attorney can help protect assets. We might need to change the ownership of assets. When Medicaid looks at somebody's qualification for Medicaid, they don't just count the one spouse or the other spouse, they combine them. And then they can have a lien on all the assets unless we do something to protect against the lien. One big tool for us to do that is through the power of attorney that has the ability to do a property status change. I don't expect anybody to understand well, that's a whole nother talk. We do have a YouTube presentation, I think, on that. I'll try to cover it if I have time, which I won't. And another thing is gifting authority. Sometimes, and this isn't just for couples, especially for single people who don't want to spend all their money before the state will pay for their care. As an elder law attorney with Medicaid expertise, we know how to protect assets so that assets don't all have to be spent down on care. One of the best ways to do that is to have gifting authority, not limited by annual exclusion gifting, which, who thinks that amount is 10,000? Most people do, because it's like now 19, it was 18 and 19, it keeps going up. So most people will say 10,000, so don't feel bad about that. We want to be able to potentially gift out everything, because that's what you would have wanted. If you could preserve everything, you want to gift it to maybe your family or to a trust or something. So we need gifting authority. And the reason I'm spending time only on these is because these are the most powerful grants of authority and a durable power of attorney, and your attorney should be talking to you about those, or if not, you should be asking these questions of them. Why don't I have that? Oh, you don't need that. Why would you want to gift more than the annual exclusion amount? You'd have to file a tax return. Well, because I want to protect all of those assets, that's why. So that's a lot on durable powers of attorney, probably more time than I should spend on it, but I think it's really important. Healthcare directive is the next living document. It's also called a living will. It's also called an advance directive. It is your end of life wishes in writing, so that if you can't speak for yourself and your healthcare agent needs to, and they have to say, stop heroic measures, they're not gonna feel guilty about that, or it'll alleviate somewhat of their guilt, because you put it in writing. I don't want heroic measures. You can say you want heroic measures. You can say whatever you want. But the point of it is, put it in writing so that it's clear what your wishes are, because if you don't have it in writing, your voice might not be heard. Any questions on the living will? I don't know why it's called a living will. It's silly. It has nothing to do with the will. It's an advanced healthcare directive. Okay. So on the right-hand side of your sheet are what happens when these are documents that take in effect when you die and that they dispose of your assets. Now, the revocable living trust is a little confusing, because if you have a revocable living trust, and many people do, what that does is that's a document you sign while you're alive, and you fund it with your assets, and you could be the grantor, which means you created it. You could be the trustee, which means you manage it. You probably are the beneficiary, which means you get a benefit from everything in it. This is your document where you put all your assets in, and it manages it during your lifetime. So it can be very helpful if you were to lose ability to manage it, because then you have a successor trustee, just like your durable power of attorney for finances, who steps in and manages it for you. The main thing about a revocable living trust is that it is beneficial if you want to avoid probate. Now, let me ask, before you look on the back side of this document, who wants to avoid probate? Right, everybody in the room. Well, I'm going to show you why you might not want to avoid probate, but If your situation is such that you don't want probate, then a revocable living trust might be a great way to go. As an estate planning and elder law attorney, I can tell you every single week we have people come in who have not funded their trust. They don't understand their trust. They don't know what to do when somebody has died, when one of the spouses have died, and the trust says they're supposed to create an irrevocable trust for tax planning purposes. They don't understand it, and I'm not expecting anybody who's a non-lawyer to understand it. So go back to your attorney if you have a revocable living trust and ask them to explain it again, and just keep in mind that a revocable living trust, while the benefit is avoiding probate, oftentimes when somebody dies with a revocable living trust, there's going to be a probate because they forgot to put an asset in the trust. So we need a probate and a trust administration. Yeah, go ahead.
If the attorney that did your revocable trust is no longer living, what is the cost to come and see you folks?
So, I probably shouldn't have chewed a bunch of ice right now, huh? So if your attorney who prepared it is no longer practicing for whatever reason, and they don't have a firm that they left behind, then you're going to want to reach out and talk to one of our team members who's going to talk with you about whether or not you will qualify for a complimentary consultation. Sometimes people don't, and so sometimes then we charge them $500 if it's a consultation where, frankly, when we charge the $500, it depends on the situation, but it could be that, you know, maybe we're not going to be able to assist you. We often help referring people to free legal services if they qualify, or other attorneys. Sometimes, but what you'd want to do is contact us to see if you would qualify for complimentary. I'm just saying, please don't be disappointed if you call and we don't say, you know, great news, you qualify for complimentary. It's not everybody who does. And then also, I'm not going to be the one you're meeting with. We have, you know, a team with a lot of depth to it, so it's going to be somebody else. For those of you that saw me back when, you know, maybe you did meet with me, but now we have grown. So I just don't want you to, not that you'd be disappointed. Why would you be disappointed? We have great people that you'd be meeting with, So the revocable living trust, one of the things I want you to be aware of is that you do have to manage it during your lifetime. It will give you 0 creditor protections. If you're listening to a lawyer who says your revocable living trust during your lifetime will protect you from creditors, they are wrong. Normally lawyers say, well, it depends. I'm saying they are wrong. So rarely do I give such a black and white statement that a revocable living trust will not protect the grantor from creditors. And it will give you no long-term care Medicaid protections. We're going to talk about that. I'm not saying revocable living trusts aren't good. It depends on your situation. Everybody's situation is different. But I do want you to understand what your estate planning documents do for you and what they don't do for you. So let's talk about a will. Everybody knows what a will is, right? A will is what is followed to transfer your assets on your death. A lot of people think if you have a will, you won't have a probate. Wrong. A will means there will be a probate unless we get down to this third column, non-probate assets. We'll talk about that. So a will is something you sign during your lifetime. It says who gets your assets when you're gone, who are your beneficiaries. A will requires probate if the will is going to be effectuated, if it's going to be carried out. Your will often will have trusts in it, tax protection trusts, asset protection trusts, especially against long-term care and Medicaid. It can have trusts for your grandchildren, trusts for your beneficiaries. Maybe they're on needs-based government benefits. Maybe they just have lifestyle issues that cause you concern. Maybe you expect there'll be a divorce of your child. There's all sorts of really good reasons to put a trust in your will. And if you do that, even though it will require a probate, you're much more likely to have that trust created for you, because probate typically requires going to see an attorney, because an attorney, our job is to make sure it's done right. And yes, we do charge for our services, which is kind of the rub, I know, for most people about why they don't want to see a lawyer. I guess the question is the benefit worth the investment?
So is the will then
Sorry.
preferable to the revocable living trust because it can create a trust upon your death?
Just basically, I would say that a will is preferable to a revocable living trust because the will be carried out, where, for the most part. Whereas a revocable living trust, very commonly we see that when somebody dies, nothing is done. If it's said you need to set up a new trust for somebody, even for like the spouse, for tax purposes, it doesn't get done. You know, the husband dies, the wife is 80, she's got a revocable living trust, he probably already managed most things, and then he's gone, and she doesn't, you know, think about going to see a lawyer. Nobody else understands what the trust is, so it never gets done. And as a result, if this couple had like $4 million, they're gonna end up paying, on her death, hundreds of thousands of dollars to the state of Washington. Our estate tax level is $2.193 million. We can easily avoid that for a couple with $4 million, even with a revocable living trust, but the problem is it doesn't get carried out. That's just human nature to say, I don't want to go see my lawyer. My lawyer's going to charge me money. So let's say your lawyer charged you $5,000 to help you administer your trust after somebody's death. That can save you hundreds of thousands of dollars, but the person doesn't know that. So they're reluctant, understandably. So I think regardless of what is the best plan for you, use your attorney. This is why it's important to us that we are an attorney that will be there for our clients as life goes on. This is why I'm not a solo attorney anymore, because that's unfair to my clients, because I need my firm to continue so that if anybody who's our client has questions, they will be answered with the same type of, you know, capabilities and respect and compassion.
Is it pretty critical to have your will looked at when you move from one state to another?
The question is, should you have your will looked at when you move from one state to another? Absolutely, because every state has different rules. So let's say you were in California, for example, and you had a revocable living trust, and in California, that will work to protect assets against Medicaid. You move here to Washington, where our probates are easy. In California, they're awful. What happens when you move here, if you don't change your estate planning, is that the whole plan no longer works. So you really need to, and maybe the lawyer will just say, you know what, Idaho and Washington were real similar, this will work. But if you move to a different state, do have your estate plan reviewed. Okay, this is what I said, estate plan isn't one and done, it's good, and then you go, oh, life has changed. I live in a different state. Oh, I've lost my spouse. Oh, my children, something has happened, So I want to talk about non-probate assets because people forget about these and they're really important. Non-probate assets are assets that will not pass under your will. And they might not be assets that you can put into your revocable living trust. So you can't forget about these assets. For example, if you have a 401k, you can't put that in your revocable living trust. So you make darn sure that your beneficiary designation pays to where you want it to pay. So don't ignore that. And if you get divorced and your 401k says it pays to your ex-spouse, they're gonna get it. Even if you don't want them to and you've been divorced. So don't forget the importance of a 401k. It could be your largest asset. Maybe not anymore. All right, account titling. If you own an account, joint tenants with right of survivorship, it goes to the survivor. Maybe that's what you want, maybe you don't. It doesn't go under your will and it doesn't go under your revocable living trust. So these are carve-outs to a revocable living trust and a will. Pay on death provision. It's just like a beneficiary designation. Think about your life insurance too, it has a beneficiary. Your bank accounts can say pay on death as well. And maybe that's good, maybe it's bad. If you're trying to avoid probate, we often set up estates to avoid probate because there's no benefit. But you have to make sure that all your accounts are properly paying where they're supposed to pay. Because if you forget one account and it's over $100,000, you're gonna need a probate, and the whole plan was to avoid probate. So are you expected to understand all this? No, that's what your lawyer is for. Take the time with your lawyer to sit down and make sure that you understand it. And don't feel like you're wasting their time or anything. It's your plan. You need to understand it, and your lawyer needs to explain it to you, okay? Property status agreements, transfer on death deeds. Transfer on death deeds, it used to be we didn't have these, and so you had to do a probate if you didn't have a trust, a revocable living trust. Well, it's changed such that if you want to avoid probate and you want your house to go to your nephew or whatever, transfer on death deed will accomplish that. So property status agreement, that's another way to avoid a probate. It may or may not be appropriate. It's, again, just something that I wanted to point out. Okay, so since we have 10 minutes, I want you to see the benefit of what a will with asset protection can do. So flip over to the next page. And I like round numbers, so we are going to deal with $1 million. So this is a will with asset protection. This is going to show you why you might want a will to be probated. So we are going to take a couple, Fred and Betty, and they own their own home, and they have investments, and they have $1 million, which sounds like a lot of money, but people are so surprised sometimes that they go, what? I have $2 million? My house must be worth a whole lot of money because I bought it for $40,000, so I don't know why it's worth so much money. But in our example, Betty has Alzheimer's, and Fred takes care of her at home, and that's really common. So together, this couple are okay. But what happens if Fred passes? Betty has Alzheimer's. She cannot live safely in her home. So Fred's will, and this was, the couple did their estate plan before Betty's Alzheimer's got so bad that she lost capacity. They have the asset protection estate plan that contains a will with a supplemental needs trust in it. When Fred dies, his will is probated. This is community property state, and without anything different, 50% of the estate, or round number, 1 million divided by 2, 500,000 goes into a trust for Betty. Let's say their house is worth 500,000 and they had 500,000 in investments. We put the 500,000 of investments in the trust for Betty, and Betty keeps the house in her own name. Under Medicaid's rules, Betty qualifies for Medicaid, even though she has $500,000 in trust. This is the power of a will with an asset protection trust and of the probate. 500,000, Fred's share of the estate, will never count against Betty for Medicaid eligibility. The money is there for her. Let's say the adult child, son or daughter, is the trustee so that they can help use that money when Betty needs it, and she'll probably need it. Because most care facilities, memory care, have a private pay period. But keep in mind, Betty also has her $500,000 house, which she might sell, or it might be a part of another Medicaid plan to gift it to the kids. There's all sorts of things we can do with that. But the point of it is that just with a standard asset protection estate plan, this couple can protect one half of their estate on the death of the first spouse, and the surviving spouse will never become impoverished, and that money will never be subject to the state lien for anything, the money in the trust, and it will go to their kids, for example, when Betty passes. So not a bad result. And one of the things I'm so passionate about sharing this information is that unless you're dealing with an elder law attorney, they don't know this. Why? Because they don't do Medicaid applications. We have dozens of Medicaid applications we're working on currently. So what I'm telling you is that an attorney that understands Medicaid rules will bring those rules back put them in the estate planning document so that you have a plan that protects you against impoverishment and complies and understands Medicaid's rules. So that is one of the biggest takeaway messages I want for you today.
Is there any point or any level of an estate value at which Medicaid spend down doesn't make sense for a married couple?
Somewhere above the taxable estate level, probably. I mean, I have couples that have $2 million, even $3 million. This plan makes sense for them because it also serves as a tax avoidance plan as well. But you know, when you have 4 million, 5 million, and you have, and especially if you had long-term care insurance, and even if you don't, you know, when you're into the millions, this might not make sense. Yes. Mm-hmm.
Are you, when you say your numbers, is that net worth, or is that cash, or is that real estate and cash?
It's a combination of everything. It's your gross
Net
estate.
worth,
Yeah, yeah. So 100% asset protection. This is what I really want you to be aware of. That let's say we knew Fred was going to die. I mean, sometimes we do. They're in the hospital. You know, the doctor says, you know, it's not going to be long. They're on hospice. Then Betty can't talk to us, but her attorney in fact can. She'll say, can you please put all the assets into Fred's name? You go, why am I going to do that? Fred's dying. Yeah. Through the estate planning documents we prepare, we can put all assets into Fred's name. When he dies, all assets are his. All assets, $1 million. Everything that this couple owns goes into the Supplemental Needs Trust. Everything is protected. She is immediately eligible for Medicaid. She may never need or may never want Medicaid, but isn't it nice to know that everything that this couple worked for, every single dime of it is protected. Never needs to be spent down for Medicaid qualification, never subject to the state's lien. It is 100% protected. So this is an opportunity that may be right for, certainly right for this couple, Fred and Betty, and it may be right for other people too. Yes?
Is this trust then initiated by the will or?
Right. So this comes into effect upon somebody's death. So it is not in effect when the couple are alive. There is, that's what I said. I don't think I'm going to get a chance to get to all the Medicaid strategies that exist when a couple is alive. There are a lot of strategies when both are alive that we can protect assets and avoid spend down. But I guess we're talking about beyond estate planning basics, and that's a really complicated Medicaid discussion. But in answer to your question, the trust and these protections take effect only when one spouse has died. Great question. All right. Did anybody learn anything, or are you guys just going, oh man, I'm just leaving, I don't get it?
I had a question. I didn't know you were wrapping up.
I think we have till 11:45, but we could probably take a little longer, I'm not sure.
For single people, is any of this asset protection available?
Absolutely, it is. I just showed you the, more of the basics, but there definitely are steps that we take with single people. Let me give you a really quick example. A single person wanted to make sure that all of his assets were protected for his son. We put him into what's called the Medicaid 5-year look-back trust. They're all out of his name, and his son was his only beneficiary. Or let's say a single person has a disabled adult child. Medicaid's rules allow for a transfer of all your assets to your disabled child, no penalty. Another possibility is Medicaid. Everybody's heard of Medicaid's 5-year look-back rule, right? By the way, it doesn't apply between spouses because they count spouses' money, both of them. But for single people in particular, what are they going to do? Well, I just gave you 2 examples. There's also a Medicaid program called Community First Choice, CFC, and it has no transfer penalty. So if your income is within a certain amount, you can transfer all your assets and no penalty under that program, and it pays for your long-term care. So I'm not saying any of that is right for anybody in this room. I'm just saying that there's a lot of things to explore, especially if anybody is facing long-term care. But one of the things that's really important for us to have is the estate planning documents in place. And then once they're in place, whatever happens in the future, we can guide you, your attorney of fact, through that to make sure that your plan will be carried out. So, any other questions? All right, I think we're going to finish on time then. I really appreciate the privilege of your time today. Thank you so much for being here. If we can be of any assistance, just reach out to us, ELG Estate Planning, and our contact information is there. Thank you again so much.